Welcome to this live stream and welcome to anybody who's watching this on replay. Please hit the like button. That helps the algorithm show other people where they can come inside the law to learn about the real justice system. Because what we do is we take cases like this that are in the news and we use them to see if we can learn something about the real justice system. And this trial, unfortunately, we're learning a lot. We're learning a lot about the parts of the justice system that are rarely seen, the ugly underbelly, if you will. We're going to start looking at this motion to recuse Judge Glanville. This is the motion to recuse Chief Judge Glanville. And by the way, people are asking me, why is he the chief judge? Well, it rotates. There's a number of judges down there. I don't know how many, maybe 15, 20, and it rotates. And that's my understanding. So that's why he is currently the chief judge, not due to any kind of merit, just because it's his turn. One of the defendants, Demonte Kendrick, by and through his counsel, without waiving any other rights to which he's entitled, files this motion to recuse Chief Judge Ural Glanville from continuing to preside over the present case and request that the present trial be temporarily halted until the present motion is heard by another judge of this superior court consistent with the uniform rule. And he cites some case law. It's vital to the functioning of the courts that the public believe and have the absolute integrity in the impartiality of judges. And that's true. This case involves 65-count RICO indictment against 28 individuals, and it goes on with the procedural history, jury selection having begun in January 2023, and here we are in June of 2024, and we're not even halfway through. Mr. Kendrick having been denied bond and incarcerated for over 2 years. A central figure in the state's case is Kenneth Copeland. This is the witness who basically was held in contempt and he was thrown in jail because he refused to testify.
I don't recall any conversation with Detective Thorpe.
I understand you can slow it down, but I'm gonna keep asking you these questions. So, do you recall texting or telling Detective Thorpe that another guy called you and said that those people were just lying?
I don't recall.
Look, I mean, if it wasn't so ridiculous, it would be comical. But that's Kenneth Copeland, folks. He was thrown in jail because he was given immunity by the prosecutors for anything that he testified to that might violate state law, but it didn't cover because it's just the local DA. It's not the federal government. His immunity did not cover any federal crimes that he might take the stand and confess to. And so he at first invoked his Fifth Amendment rights, as his lawyer rightfully told him to, because his immunity grant wasn't broad enough, and the judge threw him in jail simply because he invoked his Fifth Amendment right. Kenneth Copeland is quite the figure here. He was sworn in, he began testifying, and despite being warned by Chief Judge Glanville that incarceration may result, he refused to testify that day. He was incarcerated by Judge Glanville, said that all parties would return to court Monday. On Monday, June the 10th, all defense counsel, this is important, all defense counsel were present in the courthouse around 8:30. They were admitted into courtroom 1C. They were seated by 9. The defense counsel waited and waited. Between 11:30 and 11 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. How'd you know that, Judge? Brian Steele, counsel for the defendant, Mr. Williams, who is also known as Young Thug, the Atlanta rapper, inquired with the court as to the nature of the delay and what had occurred. Judge Glanville refused the inquiry. At that time, unknown to any member of the defense counsel, waiting during the waiting period in the morning, upon information and belief, and this is what lawyers say, it basically says, I have a good faith belief for stating this, an ex parte meeting was held in Judge Glanville's chambers. Judge Glanville was present, Assistant DA Love, Assistant DA Hilton, and other members of the Fulton County DA's office, that's Fannie Willis' office, deputy sheriffs, and the sworn witness, Kenneth Copeland, and Kenneth Copeland's attorney. No member of the defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. The ex parte, the one-sided conversation with this judge was unlawful. It was improper. It was a violation of the canons of judicial conduct. And then the Judicial Qualifications Commission, it's my understanding here in Georgia, they have the power to police these things. They are already involved in looking into this. So the lawyers rightfully are complaining about this, but they go on here and they say, upon information and belief, neither Judge Glanville nor any member of the court staff made any member of the defense counsel aware of the ex parte meeting, either before the ex parte meeting was held, during it, or after. The complainant briefly testified prior to a lunch recess. This is where it gets really interesting, guys. One or more of the defense counsel were later made aware of the ex parte meeting with sworn witness Copeland, and they were made aware of at least some of the content and subject matter. And see, this is what the judge is. He's like Captain Queeg looking for. He's obsessed with his strawberries. For those of you who are familiar with the reference from the Caine Mutiny, he's obsessed with finding out who told on him. Okay, who dimed him out? Who told these nasty defense lawyers that I'm back here holding this illegal ex parte? They learned, it says, upon information and belief, the following events occurred. Copeland announced that he would invoke his Fifth Amendment rights and not testify. Copeland stated he would sit in jail for 2 years rather than testify. Chief Judge Glanville informed Copeland that he would keep him incarcerated until additional defendants were tried, not just the 6 defendants that are currently on trial. Remember, there's a lot more of these defendants that have not gone to trial yet. They were severed for various reasons. So according to this allegation here, Glanville is threatening this witness that I'm going to hold you in jail, I guess indefinitely, because it could be decades before all of these defendants are tried. This is how broad this judge thinks his contempt power is. And the fact that he's being accused of this alone is reason enough for him to hit the pause button on this trial, let another judge take over the trial, and let all this stuff be sorted out. Because if these allegations are true, that is absolutely stunning. That's intimidating a witness. He's basically accusing the judge. This lawyer is accusing the judge of being a part of the prosecution team. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. So the judge is saying, I'll keep you here till they're all tried. And the prosecutor is saying, that's right, we got at least 12 more of them to try. Upon information and belief, following the above coercive actions by Judge Glanville, in conjunction with one or more attorneys from the Fulton County DA's office and the sworn witness Copeland, after that, he said, okay, I'll testify. I give in. Says Judge Glanville also presented Copeland with a printout of Georgia's perjury statute and the false statement statute. So the judge, according to these allegations, the judge is saying, look, here's the law that says if you don't testify truthfully, they can prosecute you. And then Copeland stated to the assistant DA Hilton that if called, he would simply lie on the stand. Upon information and belief, in response to that, Copeland, ADA Hilton, that she would not prosecute Copeland if he were to lie on the stand. Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas. Okay, so the killer of Donovan Thomas is one of the big deals in this trial. Copeland is saying, he's back there in chambers with the judge and everybody, saying that he would testify he killed Donovan Thomas. And after that, Hilton said that, all right, if you testify that you killed Donovan Thomas, she's going to prosecute him for perjury if he testified to that. In other words, if you don't testify the way I want you to, I'm going to prosecute you for perjury under that statute that the judge just pulled out and showed you. If true, these allegations are enough to get all these people fired, disbarred, potentially prosecuted. This is third world, banana republic, kangaroo court craziness, guys, if this stuff is true. And this is what the lawyers are claiming in their motion to recuse the judge. If you raise these issues and assume that they're true, does this show that the judge could reasonably be believed to be impartial? And the answer has to be yes. During court on the afternoon of the 10th, when one or more of the allegations were presented to the court by Attorney Steele, Judge Glanville denied that one or more of the events related to him were accurate. He didn't deny, of course, as we recall, the ex parte communication, but he denied that at least some of those may not be accurate. They point out here in the motion that the judge must cease to act and make an immediate determination. Okay. Well, where are they getting that from? It says here, this is the uniform rules of the Superior Court. When a judge is presented with a motion to recuse, disqualify, accompanied by the affidavit, the judge shall temporarily cease to act on the merits of the matter. So they're not making this up, folks. The lawyers are dead right on what they're claiming here in this motion, what the law requires. They're dead right. All right, you go on to say, when a trial judge is presented with a recusal motion or accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely. And by that, look, once a lawyer has information that a judge is, that would call into question the judge's impartiality, he's only got 5 days. He or she only has 5 days to raise this. And so that's what they mean by timely. If the affidavit sets forth facts that, if proved to be true, would warrant the assigned judge's recusal. So look, assuming that any of those facts that are alleged were true, would they warrant recusal? Hell yeah, they would. There's no question that they would. So you've got to look at it objectively and say, look, without deciding if these things are in fact true, assuming they are true, would they warrant recusal? And if the answer is yes, then he's got to send it to another judge to fully flesh it out. So they have an obligation, folks, under the law to do this. They've got to raise this issue within 5 days. And the judge is mad that they're raising the issue. Instead, the only thing he's worried about is who is the leaker. That's all he cares about, is finding out who is the leaker. Given that the most recent incident demanding recusal just occurred on June 10th, a 2-day period elapsing from the incident is good cause. So it's only been a few days. So it's timely. And the present motion includes a sufficient affidavit. In an accompanying affidavit by Douglas Weinstein, Exhibit 1, with evidence for recusal has been filed and now presented, which fully asserts facts upon which this motion is founded. A review of the Weinstein affidavit clearly states the facts and the reasons. It's specific with respect to time, place, persons, and circumstances. The particulars of the Weinstein affidavit are provided above and need not be presented again here in detail, but lays out the alleged actions of Chief Judge Glanville in connection with the state with respect to sworn witness Copeland that took place in the chambers of Judge Glanville, June 10th, 2024. Recusal is warranted. Okay, let's see why they're saying that recusal is warranted. The facts alleged in the Weinstein affidavit must be assumed to be true when deciding whether recusal would be warranted. The details learned by Weinstein detail the holding of an improper ex parte hearing conducted with sworn witness Copeland, which violated the constitutional and statutory rights of Kendrick, including the right to due process and a fair trial. What do they mean by that? If a witness is meeting with the judge and with prosecutors back in the judge's office, anything that witness says is grounds for cross-examination. In other words, when you cross-examine a witness, you're looking at things that may cause the witness to be biased, things that may reflect bias. Do you think that a witness might have some motive to testify maybe more in favor for the prosecutor if they've just left a meeting where the judge is threatening to hold them in jail indefinitely if they didn't testify the way the prosecutor wanted them to? And that's kind of what they're saying here is happening. And that would be a thing that you would want to cross-examine that witness on in front of the jury. But by denying them access to the meeting and and of course, denying them later transcripts of it, you're denying these lawyers their right to cross-examine the witnesses called against their clients. It's called the right of confrontation. It's in the Constitution. It's the confrontation clause. You got a right to confront your accusers, and that means you've got a right to cross-examine with the assistance of counsel, the effective assistance. There's so many constitutional rights at play. You got the Fifth Amendment, your Sixth Amendment, your due process rights. All these rights are being implicated here by this alleged judicial and prosecutorial misconduct. Let's get back into this. The ex parte hearing with sworn witness Copeland was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct. This is the relevant part. Judges shall not permit or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. And I won't go through all of them, but none of them apply. Rule 211 of the Revised Code of Judicial Conduct says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one, okay? Remember, at the beginning of this stream, I shared with you guys this right here. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. That is an objective standard, meaning if you look at it sort of in the, not subjectively, but as the unbiased, impartial third party objectively looking down on it, if you look at these allegations, would the judge's impartiality reasonably be questioned? So that's what they're talking about. The standard is an objective one. The facts must be considered from the perspective of a reasonable person rather than from the perspective of interested parties or their lawyers. Judge Glanville should not have coerced witness Copeland to testify. Well, that sounds obviously true to me. A trial judge should not attempt to intimidate a witness to testify on behalf of the state. That seems like you don't need to cite case law, but nevertheless, there you have some. It goes all the way back to 1938, in this case, Benson versus State. That's just how obvious it is. More case law, it says, and they point out here, defendants were not provided notice of the hearing before, during, and after. Defendants should have been afforded the opportunity to attend any hearing with a sworn witness. That means somebody who's already under oath and in the process of testifying, like Copeland. They should have had an opportunity to be there. They're saying he's being coerced to testify, coerced by the judge and the prosecutor. The only logical conclusion, according to this motion, to be drawn by the willful exclusion of all defense counsel among Judge Glanville, the state, and sworn witness Copeland was to harass and intimidate the witness into testifying. Given that the facts as alleged must be assumed for purposes of evaluating this motion to be true, the Weinstein affidavit is sufficient and recusal would be authorized under the facts. Another judge should hear this motion to recuse. So that, of course, is accurate and true in all respects. Wherefore, Mr. Kendrick respects that the present motion meets all the requirements for recusal. This motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion, Mr. Kendrick requests that the court make specific factual findings and submits that Glanville should voluntarily recuse himself, which he could do, and avoid all this. Should the court take neither of the above actions, Kendrick moves for a mistrial due to the ongoing bias of the court as evidenced by the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial under the Constitution. All right. Let's move on down. Let's see what the affidavit says. We'll get past the certificate of service. Okay, here's the affidavit. Weinstein affidavit, personally appeared. Okay, sworn witness Copeland had been, this is some of the same things that were included in the motion. Copeland being held in contempt. Judge Glanville is presiding over the case. Glanville instructed the witnesses and parties on June 7th that Copeland would be jailed and returned to court. That's true. Defense counsel present in the courthouse. These were recited in the motion itself. This is the affidavit that must accompany. It's required to be accompanied to accompany the motion to recuse. Otherwise, the motion to recuse is facially invalid. It's the same thing between 11 and 11:30. Judge Glanville took the bench, announced Copeland was prepared to testify. Okay, so far it's the same things that we've just been over. We've got the threats. I'm just looking through to see if there's anything different in here than what we had in the actual substance of the affidavit. And it looks like, nope, it looks like that's it. So we've got the entirety of the affidavit here has been included in the motion to recuse. The judge should have immediately stopped acting on the case itself, should have reviewed that motion, reviewed the accompanying affidavit, and for purposes of that review, the judge should have assumed that the factual allegations alleged in the affidavit were true, and if so, asked himself the question, would that call into question his impartiality? Okay, and the answer has to be yes. Then automatically the statute, the rules require at that point that the case be sent, the motion, not the case, but the motion to recuse go to another judge. Because it's kind of like grading your own papers. Back when I was in grade school, we would have to pass our paper to the person across the aisle from us, and you trade papers and you grade the quiz or whatever. So you didn't wind up grading your own paper. Well, this is what that was. This was the judge grading his own paper. He was passing upon the wrongfulness or not wrongfulness of his own actions. Okay. And this is all has nothing to do with, I mean, this issue here about recusal, it's related to his improper ex parte, which can cost him his job, I think, in at some point. But this is about him not continuing to serve as the trial judge in this case. I don't know why he can't just say, look, because if it was me, whether I did something wrong or not, but if these kind of allegations were made, I would say, all right, look, I'm going to go ahead and have my colleague, the judge so-and-so down the hall, who's got the next 3 years free, apparently, I'm going to have that judge take over the trial of this case. And I'm going to go ahead and recuse myself. Because at this point, the hole is getting dug deeper and deeper and deeper, almost by the day. I'm sure that when we finish this live stream and I check in on the trial to see what's been going on the last few hours, I'll find something else that's just craziness. And it's every day.